Real property, acquisition, transfers of ownership, also powers of the state. The most obvious method of acquiring real estate is purchasing it. This involves a land sale contract, a period of due diligence to check the title, then when the monies are paid, the old owner assigns title through a deed of assignment to the new owner and the conveyance is closed. As we will see, there's a strong argument in favor of buying insurance when purchasing real estate in the United States. The property acquisition process usually starts with a contract of sale. The statute of frauds applies, so the contract of sale must be memorialized in a writing. The writing could be on a formal manuscript, a napkin, a beer mat, a check. Virtually anything written qualifies as a writing. There are 5 pieces of information necessary in the writing to form a valid contract of sale. The property and the price and the parties need to be identified. Then there needs to be language confirming that this is indeed a contract of sale. Finally, the writing must be signed. Signatures of both parties is nice to have, but not necessary. If the seller is asserting the contract, he needs only the signature of the buyer. If the buyer is asserting the contract, he needs only the signature of the seller. It's not necessary to show the boundary lines or detailed description of the property sold. The court will allow an address, brief description, or simply the red house owned by the seller. As long as a little research enables the property to be identified, the writing is generally accepted by the courts. Deeds and titles are sometimes confused. It's not surprising, as the two are interrelated, but they're very different things. A deed is the legal document commonly used to transfer ownership of real estate from the seller to the buyer. The deed is evidence of ownership, but it's really just a piece of paper. Title is much more valuable, as title defines who owns the property in the eyes of the law. Clear title is the phrase used to state that the owner of real property owns it free and clear of all encumbrances. There may be some encumbrances with marketable title, such as an easement enabling electricity and water supply to the property, but marketable title is sufficiently free from defect that the courts will legally force its acceptance on a buyer. If deeds were pizzas, a quitclaim deed would be a bare crust, whereas the warranty deed would contain a variety of appealing toppings. A quitclaim deed transfers whatever interest the maker of the deed may have in the particular property. If the seller holds only a license to park his car on the property, this is the only right that's transferred with a quitclaim deed. A warranty deed, however, contains covenant of title. A general warranty deed contains all 6 of the covenants of title, 3 present covenants and 3 future covenants. The 3 present covenants of title provide assurances of ownership, known as sizing, assurances that the seller has the right to convey, and assurances that there are no encumbrances such as liens, mortgages, or easements at the time the deed is delivered. In the future covenants of quiet enjoyment and warranty, the seller promises to protect the buyer against anyone who comes along later and claims paramount title to the property. In the covenant of further assurances, the seller agrees to execute any other documents the buyer may need in future to protect the buyer's interest in the land. The buyer is able to sue the seller in court and claim damages if any of these covenants are breached. As no such assurances of title are made in a quitclaim deed, the buyer is unable to win damages from the seller in a court action resulting from title disputes. If the buyer completes the land sale transaction and then finds he's faced with a claim by someone else with a better title, can the buyer claim compensation from the seller via the courts? Of course, if the claim was merely a quitclaim deed, the answer is no. The seller made no assurances of title, and the buyer would have no recovery. With a warranty deed, the buyer can sue, but needs to select the most appropriate covenants to use as the basis of the claim. The time window available to sue under present covenants can be limited, as the statute of limitations starts when the deed is delivered. Often the statute has run by the time the competing claim of title surfaces, and the suit is therefore barred. The present covenants protect only the current buyer, and they don't run with the land, so they cannot be passed to subsequent buyers. Future covenants, such as the covenant of quiet enjoyment and the covenant of warranty, are often the most effective for the buyer to use. The statute of limitations to sue under one of these covenants starts to run when the competing claim of title is asserted, and these covenants run with the land, so not only the current buyer, but future buyers of the property are able to sue the seller for breach of covenant. The term signed, sealed and delivered refers to the passing of real property ownership by deed. The final stage of the real estate conveyance involves a deed of assignment, transferring title from the old owner to the new one. A valid deed contains identification of the property, the parties themselves, words passing title, and the signature of the grantor. The price is necessary in the prior land sale contract, but it is not required, and not usually present in the deed of assignment. The deed does not require the price, date, consideration, or even the signature of the buyer, the grantee. A corporation is unable to sign the deed itself, so it has to assign agents in the form of officers to sign on its behalf. In most situations, authority to grant deed to real property by a corporation involves the signatures of two of the officers, such as the president and the CEO, and the deed is stamped with the official company seal. If the sale of the real estate is a sale of all, or substantially all, the company's assets, then further authority may be required from the board of directors, and depending on the bylaws, from the shareholders. The deed does not pass title until it's delivered and accepted. This requires an act by the grantor with intent to pass title immediately. This means the grantor must be alive to deliver the deed with intent, and the passing of title cannot be delayed until some future event. A deed that's recorded by the grantor is deemed to have been delivered. The recording was an act by the grantor and shows intent to pass title immediately. A forged deed or an undelivered deed isn't worth the paper it's written on, and does not pass title. Closing these transactions creates a circular problem. The buyer refuses to pay the purchase price until she has the deed. The seller refuses to assign the deed until he receives the purchase price. We have a stalemate situation. The solution is escrow. The purchase funds and the deed are placed with an impartial third-party escrow agent. The escrow acts as agent for both buyer and seller, with instructions from each. The buyer places the funds with the escrow agent with instructions to pay when the agent has the deed from the seller. The seller places the signed deed with the escrow agent with instructions to provide the deed to the buyer when the agent has received the full purchase price from the buyer. Escrow is a valid form of deed delivery and is commonly part of land sale transactions. There are often at least two deeds of assignment in a closing conveyance. In the first deed, the seller passes title to the buyer. In the second deed, the buyer passes a claim on the property to the mortgage lender. Does it matter whether the mortgage deed is signed by the buyer before the deed passing title is signed by the seller? Generally, the answer is no. Mortgage lenders insist the buyer provide them with a warranty deed. When the mortgage deed is executed, the buyer has no title to the property, so the lender is somewhat exposed. But when the deed is signed by the seller, passing title to the buyer, the mortgage deed suddenly becomes effective. This is a result of the after acquired title doctrine. Of course, the mortgage lender would be fully exposed and would have no claim on the property if the buyer merely provided the lender with a quitclaim deed. The buyer would be transferring only the interest he currently held in the property to the lender, and this would be nothing at all if the mortgage deed was executed first. Not surprisingly, mortgage lenders insist on the use of warranty deeds and rely on the after acquired title doctrine to assure they get their lien on the property regardless of the order the deeds were signed. If the parties form a contract for the sale of the property, and one of them then withdraws from the transaction, breaching the contract, what are the remedies available in court? Firstly, as the property is unique, the court has the ability to order specific performance of the contract. The court can order that the contract is performed and the sale is completed. The buyer can be forced by the courts to buy. The seller can be forced by the courts to sell. Another option available to the court is to cancel or rescind the contract. This usually results in return of the deposit made by the buyer. Money damages are available to compensate the injured party. The courts take into consideration changes in the fair market value of the property between the time the contract was formed and the time the case is heard. The objective of the court is to put the plaintiff in the position she would be in if the property sale had been completed. A liquidated damages clause can be written into the contract and will generally be upheld by the court, if considered reasonable. 10% or less of the purchase price is generally considered reasonable. Where the statute of frauds has not been satisfied and there's no writing to memorialize the contract of sale, under its equity power, the court will often look to part performance as a substitute for the writing. The courts will enforce the contract if two out of the following three actions take place. The buyer takes possession of the property, makes a partial or full payment to the seller, or makes improvement to the property. In each of these situations, the court will view the steps taken by the buyer as evidence of the formation of a contract, regardless of whether the contract was memorialized in a writing. When it comes to providing a remedy, though, the court sitting in equity is unable to award money damages. So money damages cannot be used to compensate where no writing exists. Specific performance is used where it does justice. The seller can be forced to sell to the buyer that took possession and made a payment or made improvements to the property. Whether the buyer can be forced to buy depends on the circumstances. If the court finds the part performance of the buyer is evidence of an unwritten contract that was breached, the courts can force the buyer to complete the purchase. If the buyer finds a defect in the property that was not disclosed by the seller, the buyer can sue the seller and the seller's broker to recover compensatory damages. The seller and the broker can each be held liable if they had actual knowledge of the defect and failed to disclose this to the buyer. They're not required to search for defects, but must disclose any defects that they are aware of. Title search is laborious but important. Once the land sale transaction is closed, the buyer takes the title, and it's then too late to challenge the sale based on defects to the title. So following the agreement of the contract of sale, the buyer has the duty of checking for marketable title. Marketable title is a title that's free and clear of objectionable liens, clouds, or other defects. A marketable title is one that enables an owner to sell his property freely to others and that others will accept without objection. A contract of sale of real property is conditioned on the seller providing marketable title. There's an implied covenant in the contract of sale that the title is marketable, and this forms a condition on the contract. A title is deemed unmarketable if there are any detrimental encumbrances to clear title that will not be discharged at the closing. Anything less than a fee simple absolute is considered unmarketable. Other encumbrances that render the title unmarketable include undischargeable liens, mortgages, covenants, boundary encroachments, easements and zoning violations. If one of these issues is discovered after the contract of sale was formed, but before closing, the buyer has the right to rescind the contract, withdraw from the purchase. Damages for breach of contract are also available to the buyer if the seller knew of the defect but failed to disclose to the buyer. Damages are always available from a bad faith seller, but they are often available from a good faith seller who was unaware of the defect. The courts are split on this, and the availability of damages from a good faith seller varies state by state. Mortgage arrangements often take longer than expected. So do title searches. So it's not unusual for real estate transaction closings to be subject to delay. When the sale is delayed, what are the remedies available to the seller? The seller can claim damages, compensation for losses resulting from the delay. However, unless the delay is unreasonable, the seller is unable to withdraw from the sale. Delays of several months in these transactions are considered reasonable. The contract is breached, but the breach is not considered material. There is an exception to this rule. That means no delay is tolerated, and any delay at all, even for a few minutes, allows the seller to withdraw from the transaction. This is where the words "time is of the essence" are used in the contract, or where the parties are both on notice that time is of the essence and the date and time of closing is critical. What happens when the property is accidentally damaged or destroyed after the contract of sale was entered into but before the closing? Under the doctrine of equitable conversion, when the contract of sale is formed, the ownership of the property is split between the buyer and the seller. The buyer becomes the equitable owner and the seller becomes the legal owner. This means that the buyer owns the real estate and the seller holds personal property in the legal title. If either the buyer or seller dies, the contract is still performed by their heirs and representatives of the deceased. The buyer does not hold title until the conveyance closes, but the buyer bears the risk of loss if the property burns down or is otherwise damaged in the period of time between the contract formation and the closing. The courts force the buyer to purchase property for full price, even when it's been burned to the ground. This is clearly an issue of some concern to the buyer, and there are several steps the buyer can take. A provision in the contract of sale can place the risk of loss on the seller instead of the buyer. Alternatively, the buyer would be advised to buy insurance when signing the contract of sale and not waiting until the conveyance is closed. The land sale contract is not terminated by the death of the buyer or the seller. The sale continues and the heirs or representatives act for the deceased. The delivery of the deed is ineffective if either the grantor or the grantee is dead. So, a live representative must step in to replace the deceased party to the contract when the deed is delivered. The escrow agent can act as a representative for the seller if he dies after placing the deed in escrow. The buyer can close the purchase so long as the seller remains alive long enough to put the deed in escrow, with instructions to deliver when payment has been received. If the deceased devised his personal property to one person and his real property to another in a will, the doctrine of equitable conversion, combined with the doctrine of exoneration, can have a significant impact on who gets what. As we learned in the previous slide, under the doctrine of equitable conversion, the buyer holds equitable title as real estate when he dies. To complete the sale, under the common law doctrine of exoneration, the buyer's personal property, in the form of cash, is used to pay for the property, the real estate. So the real property portion of the will is enhanced at the expense of the personal property. The real estate is enhanced at the expense of the cash in many cases. The relatives of the deceased may be upset at his passing, but the recipients of personal property have reason to be more upset than those receiving the real property. On the other hand, it's the recipients of real property in the will that lose out when the seller dies. Upon signing of the land sale contract, the sellers lost ownership in the real property and held the remaining interest as personal property. So the takers of personal property under the will gain at the expense of the takers of real property. The person awarded real estate in the deceased seller's will get to hold legal title, but only until the conveyance is completed, when he has to pay the title to the buyer, past title to the buyer. It's not unusual for a debtor to try to hide his assets from creditors. Creditors can become very upset when a debtor sells property to a friend or relation at below the market price, and the courts, both state courts and bankruptcy courts, often support the creditors by declaring the sale a fraudulent conveyance. The court will set aside the conveyance at the request of the creditors. Ownership of the property goes back to the debtor, where it is accessible to his creditors, regardless of whether the purported buyer recorded his ownership or not. When buying a property, it's strongly advisable to record the purchase with the state. Although common law vests ownership in the first buyer, if you fail to record, you may lose the property to a subsequent buyer. It's not impossible for unscrupulous sellers to print 2, 3, or more copies of a deed and sell the same property several times. To counter problems caused by this type of activity, the states have established systems where property transfers are recorded in a public record. If the first buyer records his title, he will prevail over subsequent buyers. Buyers 2 and beyond will be unsuccessful in claiming ownership on account that they obviously failed to check the records. The recording by buyer 1 puts the world on notice that buyer 1 was now the owner of the property, so the fault lies with buyer 2. When buyer 2 is faultless in the transaction, there are 2 faultless good faith buyers. Statutes have been established by each of the states to resolve these disputes. Some states base their decision on notice. Buyer 2 wins if he is a bona fide purchaser, i.e., he pays value for the property and has no notice. A bona fide purchaser is one who buys property without knowledge or notice of any defects in the title of the seller. Other states prefer the foot race approach. Buyer 2 wins if he's first to record. Some prefer a combination of both notice and race. To prevail over buyer 1 in one of these states, buyer 2 must be a bona fide purchaser and win the race to record. A bona fide purchaser, 1, pays value, and 2, has no notice of the competing claim. Let's dig down a little deeper to understand what this means. A purchaser paying full market price for the property in cash is obviously paying value, but payment in cash is not the only way of satisfying the value prong of the bona fide purchaser test. Value can be found in debt forgiveness, debt rescheduling, payment in alternative forms of currency, barter, and trade deals. The key is that the buyer has to give up a valuable legal right, more than merely nominal value. Paying $1, $10, or some nominal price does not qualify the buyer as a bona fide purchaser. Neither does receiving title to the property as a gift. It's not only claims of title from purported owners that trigger the bona fide purchaser test. Claims from mortgage and lien holders are also required to be supported by value. This issue often arises when the lien on the property is provided to the lender sometime after the loan was advanced to the property owner. Contract concepts of consideration apply, and unless the lien is contemporaneous with the loan, it does not qualify the lender as a bona fide purchaser. Of course, the lender can provide some other form of value or consideration at the time the lien was created, such as an agreement to reschedule payments or suspend foreclosure. This would involve giving up a valuable legal right at the same time as the claim was created on the property, so the lender could qualify as a bona fide purchaser. A court judgment lien against the property owner does not, in the view of the courts, represent value. Although the owner of the lien has prevailed in a lawsuit against the property owner and been awarded damages secured by a lien, this is not considered by the courts to constitute value and does not qualify the holder as a bona fide purchaser. Turning to the notice prong, what do we mean by being on notice of a competing claim on the property? Well, a buyer is expected to 1. Search public records, searching for deeds or recorded claims against the property. 2. Search references in public records. This means read all the documents recorded against this property and investigate any references to competing claims. 3. Listen to whispers. Whispers by nosy neighbors can create actual knowledge and place the buyer on notice. 4. Inspect prior to purchase. This involves visiting the property and looking it over. 5. Inquire prior to purchase. If someone's living on the property, inquire as to the lease or rights to stay there. Ignorance and lack of due diligence is no excuse in the eyes of the court. If you fail to perform any of these checks, and they would have uncovered a competing claim on the property, you're deemed by the court to be on notice of the claim. You're not a bona fide purchaser if you buy when you're on notice of an encumbrance to clear title. So, the Recording Acts do force buyers to undertake due diligence when purchasing property. However, they're only expected to conduct the searches once. The buyer is not expected to carry out repeated searches. Even a buyer in an installment payment transaction is not expected to undertake due diligence more than once. Where the buyer is unable or unwilling to raise the monies to buy the property from a bank or third-party lender, she might reach agreement with the seller to acquire through installment payments that take place over a number of months or years. In these installment contracts, often the buyer is the equitable owner, but does not get title and become the legal owner of the property until the final payment is made. Issues arise in the courts when the installment buyer fails to record her interest, and the seller then sells the property to a cash buyer. We now have two competing ownership claims on the property, one from the installment buyer that failed to record, and the second claim from the cash buyer. Both of them could be bona fide purchasers in that they both take without notice, and they both pay value. The courts settle these disputes in a variety of ways. Some courts will give title to the cash buyer and provide the installment buyer with a lien to recover the installment payments she has paid. Some will make the cash buyer and the installment buyer co-owners of the property as tenants in common. Each one's ownership is proportional to the amount she paid. The third approach taken by the courts is to have the installment buyer complete the purchase, but make the installment payments to the cash buyer. When the installments are completed, the title goes to the installment buyer. It is very possible to pay for property that you don't own, and it really makes sense to buy title insurance when acquiring property in the United States. For this reason, title insurance is part of almost all property transactions. It's not possible to assure yourself of clean title by searching the public records. As we learned on the previous slide, some titles are written into deeds but unrecorded with the state. Others are misrecorded due to a clerical error. The other problem is that many ownership rights are unwritten, so they can't be recorded or show up on the public records. Claims of adverse possession of the entire property are not written or recorded at all, so the same is true for prescriptive easements based on principles of adverse possession. Implied easements are not written or recorded, and the same is often true of boundary adjustments. A verbal agreement between two neighbours to adjust the boundary between their properties can be binding on the subsequent buyer. Even an adjustment in the boundary that is not agreed but goes unchallenged can be binding on the new owner. So title insurance is important in protecting buyers from these hidden obstacles to gaining clear title. If one owner takes clear title, the shelter principle allows subsequent owners to benefit from the same protection. In any link in the chain of new title, the new owner takes all the rights held by the prior owner, so when one owner holds clear title, this will pass to all subsequent owners under the shelter principle. Just as the states have enacted lemon laws to protect buyers from vendors marketing substandard new cars, purchasers of new residential properties are protected by warranties imposed on builders. Designed to protect individuals and families purchasing new homes, these statutes apply to houses, apartments and condominiums, and do not apply to pre-owned residences or commercial real estate. If the structure of the property is unsound or lacking adequate workmanship, the initial owner, the buyer that acquired the property from the builder directly, is able to sue the builder for breach of implied warranty. What precisely is covered in the warranty varies from state to state. If not ejected by the owner, a trespasser claiming exclusive possession can become the owner of land. Wrongful possession ripens into a legal right to possession. The US courts have little sympathy for plaintiffs that sleep on their rights, and it is possible to gain ownership of real property by simply moving in and staying there for a period of time. The concept is known as adverse possession. This requires possession, and it has to be adverse for the statutory period. Possession must be actual and must be appropriate to the nature of the land. Adverse means a claim of right as owner, denial of ownership by others, and the exclusion of others. The adverse possessor must exclude other potential adverse possessors, as well as the true owner of the property. If there are several competing adverse possessors, they all fail to gain title as they fail to exclude others. The person claiming ownership of the land must prove that his possession was open and notorious. This means it was obvious and not secretive. He must further prove his possession to be hostile and under claim of right. This means he's claiming ownership, not merely a temporary license. Ownership must be continuous for the statutory period. However, the adverse possessor is